So good morning, everybody. Can you hear me? So after yesterday's very interesting presentations, we go now also to other interesting presentations and perhaps to have a little bit more optimistic approach. We're starting with the tort law reform in Belgium with Professor Geert Jocque. So you have the floor.
Thank you very much. Good morning, everyone. Thank you for the organization and the invitation. I'm honored to be here. When we look to the subtitle of this conference, we can read, "Why is tort law reform so difficult?" Tort law may be difficult to reform, but it is not impossible. So I will tell you this morning an Austrian or a Swiss or a French drama, but rather a Belgium success story. So I'm pleased and somewhat proud to present to you the new Belgian contractual liability law. The Belgian legislator has succeeded in creating a new liability law after years of preparation. On the 1st of February of this year, the Belgian Parliament approved the law containing Book 6, Extra Contractual Liability of the Civil Code. This law will be published in the Belgian Monitor, Belgisch Staatsblad, on the 1st of July. Monday coming, it will be official in the Monitor of Belgium and will enter into force the 1st January 25. You have received an unofficial translation in English of Book 6. This translation is not perfect, but you can follow the text on this paper. Book 6 was prepared by a committee of experts, including colleagues Professor Hubert Bocken and Professor Bernard Dubuisson, both well known to you, and myself. This committee had met numerous times and prepared a multitude of preparatory notes. These notes, some of which can be found in the official explanatory memorandum to the new law, contain a wealth of information on the new Belgian extra contractual liability law. The new law came about as part of the recodification of the civil code in Belgium, which still largely dated from 1804, the Code Napoleon. Several new sections of the civil code have already become disappeared. I have nothing here. It's over there, yeah. No, I have nothing. There it is, but not here. Oh, no. A little technical problem. Well, no. It's a bit difficult, but it changes all the time.
But here it's stable.
Yeah, there is it stable. I will. Is it here stable? Yeah. Stable? I'll sit here. Yes, thank you. The new Belgium law came about as part of the recodification of the civil code, which still largely dated from 1804, Code Napoleon. Several new sections of the civil code have already become laws, such as Book 3, Property Law, Book 5, Law of Obligations, and Book 8, Evidence. Now it is Book 6's turn for the extra contractual liability. that in the context of this codification movement, extra-contractual liability law also needed to be addressed was obvious. The 6 provisions of the Civil Code of 1804 no longer met contemporary social needs. Non-contractual liability law had in Belgium developed jurisprudentially for 2 centuries, but it was time for the legislator to adapt the rules to social and technological developments, to eliminate disputes and ambiguities, and to make the rules simpler and more readable. Moreover, the Court of Cassation has often reached the limits of its ability to find new solutions by interpreting the old rules. The Committee of Experts has tried to reach a balance between provisions who give at a judge the basic rules of tort law at the one hand, and who let, at the other hand, enough space for the judge so that he can find a just solution in a concrete case. Another difficult balance was between conservation of the current case law and innovation. It was politically not realistic to write a complete new tort law. Otherwise, only codification of the existing case law had no sense. So, some provisions of Book 6 adopt the case law of the Court of Cassation, and numerous other provisions provide innovative rules that modify existing law. It should be noted, however, that Book 6 does not regulate the entirety of extra-contractual liability law. For instance, this book does not contain provisions providing for coordination with other compensation systems, such as insurance law and social security law, nor are the numerous special liability regimes, such as traffic law or industrial accident law, included in Book 6. So, what do we find in our new Book 6? This is...
You can continue.
Yeah, thank you. This is the subject of my contribution. I focus mainly on the most important innovations. I hereby follow the structure of Book 6, and you can follow also on the text, and deal first with a general provision on the relationship between contractual and extra-contractual liability, and then deal with the facts leading to liability, causation, damage, and compensation. I change. Okay? So, I will first dwell on a controversial issue in Belgian law, not only in Belgian law, namely the concurrence of contractual and extra-contractual liability. For decades, there has been a dispute in Belgium as to whether a contracting party okay? Whether a contracting party who suffers damage due to the faulty conduct of the contractual counterparty can also invoke extra contractual liability against that party. According to established case law of the Court of Cassation, that is not possible except when the fault also constitutes a crime. Book 6 now fundamentally changes this case law. Concurrence of contractual and extra-contractual liability is in principle possible, albeit with some limitations. The principle is based on the idea that when the conditions of application of the law are fulfilled, this law should apply. The rules of non-contractual liability nevertheless do not apply when the law or the contract provide that the application of the extra contractual liability law is excluded. Moreover, the liable contracting party may invoke against its co-contractor the defenses arising from its contract with the injured party, for example, the application of an exemption clause, or defenses from the law and on special contracts and from specific rules on prescription applicable to the contract. Non-contractual liability rules should not be used to circumvent the application of these rules. However, there are exceptions to this limitation, namely, when the injured party claims compensation for damage as a result of harm to his physical and psychological integrity, or through an error committed with the intent to cause damage. In such cases, the injured party may rely on the rules of non-contractual liability without limitations. The same rules now also apply when a contracting party relies for the performance of its contract on another person with whom he has concluded a contract for this purpose. The latter is then the auxiliary agent of the contracting party for the performance of its contract concluded with the principal. Under the existing law, the auxiliary agent is immune. He cannot be sued on a contractual basis because he has no contract with the claimant, this is the principal. And extra contractual liability is also not possible as he is executing the contract of the principal and his co-contractor. Book 6 also changes this case law of the Court of Cassation. If the auxiliary agent causes damage to the principal, the latter may invoke extra contractual liability against the auxiliary agent, albeit with the same limitations that apply to the injured party's claim against his co-contractor. Moreover, the auxiliary agent may also invoke defenses from the contractual relationship between himself and his own co-contractor. These new rules should improve the situation of the claimant. Consider the claimant of a construction work who suffers damage due to the fault of the subcontractor, who is the contractor's auxiliary agent. Unlike under the current law, the subcontractor can now, in principle, be held extra contractually liable. Due to the many exceptions, however, the future will have to show whether the claimant will actually be in a better condition than under current law. Let us now look at the various grounds of liability, and in the first place to the fault liability. For fault liability, the basic rule remains that every person is liable for the damage he causes to another by his fault. The fault consists of a breach of a statutory rule imposing or prohibiting a specific behavior, or of the general duty of care applicable in society. And the general duty of care is defined as the duty who requires behavior consistent with that of a prudent and reasonable person placed in the same circumstances. This description of the fault sounds for us all very familiar. However, there is a fundamental difference with the current law. Under the current law, liability only arises when the person who caused damage is capable of being aware of the consequences of his actions and can be blamed for the act by which he caused damage. This requirement of culpability, also known as the subjective element of fault, disappears under the new law. A wrongful act is sufficient. Culpability is in principle not longer required. As for the general standard of care, I draw your particular attention to the criteria the law now stipulates for its application. To this end, the following may be considered, and these criteria are not exclusive. It's not a checklist. It's only criteria that the judge can take into account. First of all, the reasonable foreseeable consequences of the behavior, to the proportionality between the risk that the damage would occur, its nature and extent, and the efforts and measures necessary to avoid it. 3, the state of the art in technology and scientific knowledge. 4, the rules of the art and good professional practices. And 5, the principles of good administration and organization. The latter criterion confirms the application of the rules of extra-contractual liability to legal persons. However, there is no longer a subject element. However, the liable party can still rely on a number of causes of exclusion of liability provided by law, namely force majeure, superior force, invincible error, physical or psychological constraint, a state of necessity, an order from a statute or from authority, self-defense, and the consent of the injured party to harm to interests over which it had the right to dispose. These defenses relate in part to the subject element of the fault. Let us now take a look at the new rules of the liability of minors. The judge no longer has to consider whether a minor who caused the damage was capable of being aware of the consequences of his actions, no longer subjective element. As a matter of fact, this was often difficult to assess. Liability is now determined solely on the basis of age. The minor under 12 years of age is not liable. The minor age 12 or older is liable, but he is not necessarily obliged to pay full compensation for the damage. On grounds of equity, the court may order him to pay only partial compensation for the damage, or even not order him to pay any compensation at all. In doing so, the court takes into account the circumstances of the case and the condition of the minor and the injured party. However, this is not possible if the minor's liability is covered by an insurance policy. In that event, the court cannot decide that no damages are due, nor limit the damages to an amount less than for which the contract of insurance provides coverage. The same rules apply to mentally ill persons who have no control over their actions at the time they cause damage. For these persons too, the court may reduce the compensation in equity or award no compensation. When we talk about minors, we should also talk about the parents and other persons supervising them. Parents' liability for damage caused by their minor children is now extended to adoptive parents, tutors, and foster parents, provided they have authority over the person of a minor under 16 years of age. The same persons are also liable for minors aged 16 or more, but they can then provide contrary evidence that the damage is not due to their fault. If they succeed in that proof, they are not liable. This rebuttal is not limited to the absence of a fault in the supervision of the minor. To avoid being held liable, the parents need to prove that they are not to blame at all. This way, the legislator wants to avoid parents escaping liability too easily. Another category of persons who can also be liable are the persons charged with supervising others. They are liable when a person, subject to their supervision, causes damage to third parties. This rule applies to persons who, based on a statutory or regulatory provision, a judicial or administrative decision, or a contract, are tasked with organizing or monitoring the way of life of other persons in a global and sustainable manner. Think, for example, of institutions for the mentally ill and institutions for some minors. Furthermore, educational institutions are also liable for damage caused by their students to third parties through their fault and any other event giving rise to liability while under their supervision. In both cases, there is the possibility of evidence of absence of a fault in the supervision. And such evidence is provided, there is no liability. As in the current law in Belgium, the new law also introduces a rule of liability of the master for damage caused by his servant during and on the occasion of the performance of his duties as a result of his fault and any other event giving rise to liability. Masters are the persons who, in fact, can exercise authority and supervision over the conduct of another for their own account. This rule also applies to legal persons under private and public law. Regarding liability for property and animals, the existing law hardly changes. The custodian of a good remains liable for damage caused by a defect of that good, just as the custodian of an animal remains liable for damage caused by that animal. The law now defines who is the custodian, namely the person who has a non-subordinate power of direction and control over the good or the animal. The owner is presumed to be the custodian of the good or the animal unless the owner proves that another person has custody. And further on, that the good is defective when, because of one of its characteristics, it does not provide the safety which a person is entitled to expect under the given circumstances. In both cases, the custodian cannot provide contrary evidence of an absence of fault. He can only contest that the conditions for liability are not met. For example, he can argue that the good was not defective or that the defective was not the cause of the damage. After defects leading to liability, Book 6 deals with rules on causation. Book 6 contains detailed rules on the causal link between the fault and the damage. The basic principle remains that effect is a cause of injury if it is a necessary condition for the latter. Effect is a necessary condition for the injury if, without this fact, the injury would not have occurred as it had occurred in the concrete circumstances that existed at the time of the harmful incident. This is the confirmation of the conditio sine qua non rule. Innovative is the provision that this rule may be departed from if the connection between the fact and the damage is so remote that it would be manifestly unreasonable to impute the injury to the person whose liability is involved. This takes into account, in particular, the improbability in light of the normal consequences of the fact leading to liability and the circumstance that this fact did not significantly contributed to the occurrence of the injury. The probable or improbable nature of the injury must be assessed in the light of the normal course of events. That the attribution must be manifestly unreasonable indicates that the decision to reject liability because of a causal link that is too remote can only be made exceptionally. Book 6 also regulates the plurality of causes. Here, the basic rule is that when several persons are liable for distinct facts leading to the same damage, or for the same fact, each liable person must compensate the injured party in full. This is also the case for the person who incites another person to commit a fault or assists them for this purpose. When the injured party himself committed a fault that is causally related to his injury, a division of liability occurs. But he is not entitled to compensation if he committed this fault with the intent of causing injury. Conversely, if a fault committed by a liable third party with the intent of causing injury is one of the causes, the injured party is entitled to full compensation. If both injured party and the liable party committed a fault with the intent of causing injury, a division of liability occurs again. The rules about plurality of liable persons end with some provisions about the recourse claims among co-liable persons. When multiple persons are liable for the same injury, the person who has indemnified the injured party may claim recourse against each co-liable person to the extent that the fact on which their liability is based contributed to the occurrence of the damages. The burden of compensation is then shared between the liable parties. A person who is liable without fault can recourse for the whole against the person whose fault fulfills the condition of this liability. Thus the person, for example, liable as custodian of a defective good, can reclaim the compensation he had paid to the victim for the person whose fault caused the defect. There are two important new provisions relating to causal uncertainty. The first rule replaces the doctrine of loss of chance. When it is uncertain whether the fault of the person against who is claimed is a necessary condition for the injury, because the injury could also have occurred if this person had acted lawfully rather than committing a fault, the injured party is now entitled to partial compensation for the injury. Compensation is then due in proportion to the probability that the fault caused the injury. The injured party in such a case does not obtain full compensation, but only partial compensation determined on the basis of the probability that the event in question was a cause of the damage. The loss of a chance is thus not a damage category, but translates into proportional liability. The second rule concerns the uncertainty regarding the identity of a liable party when there are alternative causes. If several similar facts for which different persons are liable have exposed the injured party to the risk of the occurrence of the injury, without it being possible to demonstrate which of the facts caused the injury, each of these persons are liable in proportion to the probability that the fact for which they are responsible caused the injury. The provision covers cases of damage, where the injured party can identify a group of persons to which the person who caused the damage belongs, but cannot identify the latter within that group. All these rules on causation may seem complex, but they have the merit of avoiding the unfair consequences of the rigid application of the conditio sine qua non rule. After the rules on causation, we turn our gaze to the provision on damages and compensation. The Civil Code of 1804 does not contain any provision on injury. All rules on damages were to be found in case law. Book 6 brings a major change to this by introducing various rules on injury and compensation. Book 6 first defines what injury is. Injury consists of the economic and non-economic consequences of harm to a legally protected personal interest. The consequences of harm to an interest must be lawful to give rise to compensation. Injury consisting of the loss of an advantage originating in an unlaw event or activity attributable to the injured party is not compensable. For example, compensation for loss of income from undeclared work is thus not possible. This provision confirms, in Belgium, existing case law. Book 6 also confirms the principle that the injury must be certain, which does not exclude compensation for future injury. A distinction is further made between patrimonial and extra-patrimonial injury. Patrimonial injury concerns any economic impact of the harm. It includes losses and costs as well as loss of profits and reduction in value. Extra-patrimonial injury refers to any non-economic consequence of the harm. It includes pain, suffering, and other psychological disorders. The injury may be directly inflicted on the injured party, but it may also occur to a person other than the one directly affected, such as the surviving partner of a fatal victim. The injury suffered by a person as a result of harm previously inflicted to another person with whom the first person has a legal of sufficiently close emotional connection is rebound injury. This rebound injury is compensable. The liable party can nevertheless raise against the injured party by rebound the same defenses as he could have raised against the directly injured party, for example, a fault of this party. Book 6 expressly provides that the injured party may also claim compensation for the expenses for urgent and reasonable measures to prevent the imminent occurrence of injury or the aggravation of injury. This means that the injury will occur in the short term if no measures are taken. He is entitled to compensation even the measures were unsuccessful. Important is that the court also may issue an injunction or interdiction against the liable party to prevent the aggravation of the injury that could result from the repetition or continuation of the harmful act. Book 6 also regulates the consequences of predisposition to suffer the injury and the pre-existing condition of the injured party. In case of a predisposition to injury, the injured party is entitled to full compensation, even if that predisposition is one of the causes of the injury. If the injured party has already suffered injury and was in a proven pre-existing state that had already resulted in harmful consequences, then he is only entitled to compensation for the new injury or the aggravation of the existing injury. Under the title Consequences of Liability, Book 6 lists the rules on indemnification. The starting point is the generally accepted principle of integral compensation. The damage must be fully compensated, taking into account the concrete condition of the injured party. This compensation can be done in kind or in the form of damages and interest. Compensation in kind aims to actually undo the harmful consequences of a fact leading to liability. The court must order the liable party to make this reparation when the injured party claims it. It's an obligation for the judge, unless the reparation claim is, you can read it, impossible, or constitutes an abuse of law, or requires the exercise of coercion on the person of the liable party, or is contrary to human dignity. When the liable party himself offers the new compensation in kind, the injured party is not obliged to accept it. But, important, he may refuse the offer if he has legitimate reasons to do so. An important innovative provision provides that the award of additional compensation when the liable party has intentionally or and with for profit violated a personality right of the injured party or harmed his honor or reputation. This additional compensation is equal to all or part of the net profit made by the liable party. Thus, this compensation does not compensate for injuries actually suffered, but aims to avoid the profit of the liable party being disproportionate to the compensation of the injured party. This may be the case, for example, in the event of a violation of portrait rights. The profit of the liable party may be many times greater than the compensation to which the injured party is entitled. Future injury resulting from harm to the physical and psychical integrity of the injured party is compensated in the form of a fixed amount calculated on a lump sum basis through capitalization or as an annuity. The choice between these methods of compensation is left to the courts. They have to take into account, among other things, the state of the parties and the interest of the injured party. Book 6 provides, in this respect, a very important innovation where the court is given the possibility to impose an annuity even if it is not requested, but in the conditions when compelling reasons related to the protection of the injured party justifies it. This may, for example, be the case with young victims who need lifelong care. Another important innovation concerns the possibility for the injured party to claim additional compensation in case of new injury or aggravation of the injury resulting from the same harm that was not yet taken into account in the court decision or out-of-court settlement. This is only possible if the injured party did not reasonably have or should have had knowledge of such harm or aggravation at the time of that decision or settlement. This provision is motivated by the social interest of compensating injury as a result of harm to the physical or psychical integrity. Book 6 further regulates also property damage, which may consist of damage to a good or the loss of a good or its irreparability. In case of damage to a good that can be repaired, the injured party is entitled to compensation for the cost of such repair. However, the compensation shall be limited to the amount of replacement of the good by a good with the same characteristics, if the cost exceeds that amount. In this respect, the injured party may also claim the decrease in value of the good after restoration. In event of the destruction of irreparability of the good, the injured party shall be entitled to compensation for the cost necessary to replace the good with a good with the same characteristics, performing the same function. The compensation is determined on the replacement value of the destroyed good, which is the sum necessary to acquire an equivalent good. The age of the good must therefore be taken into account when determining the compensation. Finally, Book 6 concludes with a very important new provision under the title injunction or interdiction. When a person wrongfully threatens to harm others only in case of an established or a serious imminent breach of a statutory rule imposing specific behavior, the court may, upon a request of a party demonstrating that it will suffer damage, not other persons, issue an injunction or an interdiction aimed at preventing the wrongful act. The requirement is that the threatened harm is the foreseeable or probable consequence of the act. No harm must have yet occurred. This rule applies only in the case of fault liability. An injunction or interdiction cannot be imposed when a person could be sued for imminent damage on the basis of strict liability. This new rule is a very strong tool to prevent damage and will undoubtedly be used in future climate and environmental cases. Dear colleagues, I hope this short overview has helped you understand the main innovations in Belgian extra-contractual liability law. Obviously, this overview is incomplete and some rules still raise questions. Is Book 6 perfect? Certainly not. But we hope that Book 6 improves the Belgian tort law and will stand for some decades. The new Book 6 of the Belgian Civil Code will undoubtedly be an important tool for legal comparison in the new future and can hopefully inspire new legislation in your countries. I thank you for your attention.
Thank you very much for giving us in less than 45 minutes an overview of these changes and underlining the most important innovations. Thank you very much indeed. I don't know whether we have some urgent questions, and then, of course, later we will have more. Yes, please.
Good morning, sir. I'd like to thank you. About the injunction and interdiction, I have like 3 questions. First, can we claim under the grounds of the general clause of fault when we are trying to prevent the damage? Second question, can we consider the injunction as a measure of compensation in kind? And is it a temporary measure?
No. First, it's only a fault liability if you have a statutory rule with a specific behavior. It's the court who decides what the measure is, limited in time, under which conditions. And what was it, the second?
If it's considered a measure of compensation?
No. Therefore, it is an article at the end of the book says, stand on itself, and is not in the title of the consequences of liability.
Yes.
So, as a technical question, as far as I recall, in the Avant-Projet 2018, Book 6 did not exist. So that was part of the Book 5th. What led to the separation from tort law from the rest of the law obligations?
Yeah. The first was a very practical situation. The provisions of obligations were ready to get in law, and the book says the rules on extra contractual liability was not, and we have split the two matters. First, they have treated in Parliament Book 5, and afterwards we discussed further on Book 6.
That means that reforming tort law was more difficult than reforming the law of obligations, to some extent.
Yeah, but it's an important question, because there are some problems of the coordination between the two. It's not always evident that you split the general rules of obligations and the rules of extra contractual liability. But I think it will not be a big problem in Belgium, like the rules are now codified.
Adam for the please. And then Matthias, behind. Yes, who was first? Yes. Sorry.
I have a very short question on the proportion of probability. Is it a question of fact?
Yes?
Or is it a question of law, and whether there is expert evidence needed, and whether experts are willing to give a percentage on the proportion of probability?
It is a question of fact. And if the judge needs some explication by an expert, he can order it. No problem.
Okay, Matthias. And then Eva.
Two remarks. First, why did we succeed? And why did tort law succeed later than other parts? We succeeded basically because there was the political will of the Minister of Justice.
Yes.
That's the main reason. Who we called him Little Napoleon because it was his clear will to push this through against all odds. And we have to thank him for that, even if you can criticize some of the results. Why the order? Property law was approved first because everybody was convinced of the quality of the project. Law of obligations took a little bit more time because not everybody was convinced of the quality of the draft. Tort law took much more time, not because we were not convinced of the quality of the draft, but because there was one single problem which delayed it for 5 years, which was the discussion about the cumul. Because the committee very strongly favored one solution, radically changing the old rules, and most other people were against changing the rules. So the result is a compromise. And the interesting about the compromise is that if you really look at the text, that it does not really change anything in tort law, and that the main change is a change in insolvency law. I can tell that as an insolvency lawyer. The main change is not that you can, that the subcontractor will be liable in cases where he was immune. The main change that is if the main contractor is insolvent, you can go directly to the subcontractor, but under the same conditions under which the subcontractor was already liable under the old system indirectly. So the real change is an insolvency law change.
You have understood that Matthias was against the proposition of the committee.
Mrs. Baginska, Professor Baginska, Eva.
I will have, hello, Geert. Just a simple yes or no, but two questions at least. You keep the word authority over children, really? Not care, nothing? Authority, like yes. Parental authority? Yeah. Okay, just to make sure that it's technical, which is not like custodiendo or something. Is it, so it's like...
it comes from the family law.
Okay. Second, what is the relation between the deduction of benefits that is, if you know, of course, because I was reading the rule that benefits with the intent, it's really, Jesus, I forgot that word is.
In the plurality of
payments and benefits 635. Payments and benefits that the injured would have not received without the fact will be deducted. Then the payments with the intent of benefiting, well, good luck with saying that benefits are not intent. Yes. And then you have concurrence with social security regimes. I thought it is included in the 635, but 654 relates... Yes. Exactly.
Yes, we have chosen for a general rule about the benefits, but in Belgian law we have many compensating systems who are regulated. It's social security law, insurance law. The specific rules exist and have to apply, but it is a general rule that apply when you have no specific rules in security law or in insurance law.
Thank you. I asked that because it was an interesting...
Yes, I haven't read it. I have not all articles because 45 minutes is...
1/3 remark is right. The product liability is there, so it will be revised.
Yes. There was also a choice. Like in France, there was the law on product liability because it is close to the damage on goods, and therefore we have put it in the book 6. But the content, the text of the product liability did not change. Yeah, of course. Yes, yeah, of course.
And the last question from Stefano Gatti.
Thank you very much. Just a short question about the profits made by the wrongdoer as a parameter for assess compensation for injuries relating to personality rights.
Yeah, you treated it yesterday. Huh?
Yeah, just a short question. Are these profits intended to compensate non-pecuniary losses?
No, it's not a real compensation.
Okay.
It is not energy. The law says you, injured party, can get a part of the profit of the responsible.
Okay, and you mentioned net profit. Does it mean that costs should be deducted?
Net, yes.
Okay,
yes,
thank you very much.
Yes.